So I guess the discussion we had this morning, we're going to hear that door to close, I'm sorry. And now for the record, the jurors out. The discussion that we had this morning about scheduling, I guess that question has been definitively, conclusively answered by the jury. And we'll read the question for the record as it is written, quote, is there any way that we can resume on Monday after today, exclamation point. Sunday is a religious day for me, period. If it is possible, period. So at least one of the jurors have told me in writing, which has never happened before, that Judge Crawford really don't want to work on Sunday. We would rather resume on Monday. And I will defer to the will of that jury, and we will charge this case, fully charge the case, and on Monday morning we'll start arguments at 10 o'clock a.m. as indicated. I have to swear in the next March term of the grand jury for the next 2 months. And they'll still be here on Monday morning at 9, and we'll start jury arguments promptly at 10. Both sides having arrested and closed this proof. Mr. Perry, Ms. Thomas, do you have any additional motions on behalf of Mr. Turner?
Your Honor, I would just like to renew my motion for the verdict.
Mr. Hagerman.
Same response as before, Your Honor. Ask Your Honor to deny the motion.
And the court will incorporate the rulings that are made at the end of the state's proof. Both sides have arrested and closed. The court still is firmly of the opinion that this is a factual issue and a credibility issue that should be resolved by this jury, and the court will deny the motion for judgment of acquittal. What the court intends to charge in the case, and it's indicated I've been working on this charge since February 28, 2019. That's when I started drafting this charge, and I made some revisions as this week has gone on. We'll charge in count 1 of the indictment, the indicted charge of first-degree murder. And at the request of Mr. Turner, waiving any possible objections to the statute of limitations, the court will also charge second-degree murder as an included offense, facilitation of first-degree murder, facilitation of second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, reckless homicide, and criminal negligent homicide. Would not charge facilitations of reckless and criminally negligent homicide because Tennessee law is that you cannot intend a reckless or negligent act, so facilitation would not be an included offense of those charges. We'll charge conspiracy to commit first-degree murder in count 2 of the indictment, facilitation of conspiracy to commit first-degree murder. Count 3, criminal attempt first-degree murder. The included offenses of facilitation of criminal attempt first-degree murder, criminal attempt second-degree murder, facilitation of criminal attempt second-degree murder, criminal attempt voluntary manslaughter, and facilitation of criminal attempt voluntary manslaughter. Would not charge attempted reckless homicide or attempted criminally negligent homicide because, again, Tennessee law says you cannot intend to commit reckless or negligent acts. So those are the court's intentions to charge the greater offenses, charge offenses, and the included offenses. Will also charge criminal responsibility for the conduct of another. As indicated earlier, those included offenses will charge criminal attempt for the conduct of another, telling the jury that a defendant is criminally responsible for an offense may be found guilty not only of that offense, but also for any other offense or offenses committed by another. If you find beyond a reasonable doubt that the other offenses or offenses committed were natural and probable consequences of the original offense, defining for the jury what criminal responsibility is, and responsible for an offense committed by the conduct of another if acting with the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the crime. We'll also tell the jury that to find the defendant guilty of criminal responsibility for the acts of another, it is not necessary that you find the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. We'll charge facilitation of a felony offense as indicated earlier. We'll give the jury a long charge on identity. And those other charges that we're required by law to charge: presumption of innocence, reasonable doubt, burden of proof, direct and circumstantial evidence, impeachment of a witness, prior consistent statements, a lone charge on witness credibility. We'll also charge the witness on accomplice and what accomplice testimony is and what or who might be an accomplice in this case. For the record, accomplice, our court, Supreme Court, Court of Criminal Appeals has defined an accomplice as someone who knowingly, voluntarily, and with common intent participate with a principal offender in the commission of a crime alleged in the charge and indictment. Among other cases, State versus Griffiths, Griffis, 964 Southwest 2nd, page 877, 1997 Court of Criminal Appeals opinion. And the court has to make that threshold decision originally. And the question, among other things, is whether or not the witness status as an accomplice is answered by determining whether that person could have been indicted for the charge offense. Tennessee case law would also indicate that if the facts about the witness participation in a crime are clear and undisputed, the trial court should determine as a matter of law whether the witness was an accomplice. However, if the facts are disputed or subject to different inferences, the jury should determine as a matter of fact whether the witness was an accomplice to the commission of these alleged offenses. And among other things, it's State versus Robinson, R-O-B-I-N-S-O-N, 239 Southwest 3rd, page 211, 2006 Court of Criminal Appeals opinion. And because of that, the court will in fact charge the jury that Jimmy Martin is in fact an accomplice in the alleged offenses of criminal attempt first-degree murder and conspiracy to commit first-degree murder, and that a jury cannot convict Mr. Billy Turner on the uncorroborated testimony of Jimmy Martin for those offenses of criminal attempt first-degree murder and conspiracy to commit first-degree murder, and that the accomplice testimony, in fact, must be corroborated, and accomplice testimony cannot be corroborated by another accomplice's testimony. We'll also charge the jury that it is a question for the jury to determine whether the witness, Jimmy Martin, was in fact an accomplice in the alleged offense of first-degree murder. And if the jury finds that he was in fact an accomplice, then the defendant cannot be convicted upon the uncorroborated testimony of Jimmy Martin. And if they find that he was in fact not an accomplice to the first-degree murder, then the jury would judge the weight to be given to his testimony just as it would any other witness in a case. And again, the court is the gatekeeper of that decision on finding that based on the record, based on the proof that is before the jury, that Jimmy Martin is in fact an accomplice to attempted first-degree murder and conspiracy to commit first-degree murder. Do not find, as a matter of law, that he is in fact an accomplice to first-degree murder because his role in that offense or the commission of the offense is in fact not clear. It is in fact subject to different interpretations. It's a factual issue as to whether or not the jury wants to believe Mr. Martin or whether they want to believe that he was in fact a party to all of this. And that is a question for the jury to make in the case, and I would give that question to the jury and have the jury determine whether or not he is in fact an accomplice. I would not charge Claudia Robinson as an accomplice to any of these indicted charges. There is absolutely nothing on the record that would indicate that Ms. Robinson knowingly, voluntarily, and with common intent participated with a principal offender in the commission of these crimes that are alleged in the indictment. Ms. Robinson indicated she was present at 2 meetings in which Mr. Martin, Ms. Turner, Ms. Wright had discussions about killing Lorenzen Wright, because Shara Wright believed that Lorenzen Wright was going to have her killed. Ms. Robinson indicated that she thought that Ms. Robinson was Ms. Shara Wright, rather, her first cousin, was not being serious. That she told her that she did not believe Lorenzen Wright would try to have her killed. They had children, thought she was not being serious about that at all, and that she basically blew it off and left. Even after Ms. Wright allegedly made statements that it's either him or me, and he has to be gone. On the second conversation, Ms. Robinson indicated she was present when this conversation again took up amongst those three people about having Lorenzen Wright killed. And her response was not an exact quote, because I'm not transcribing the record, but what I wrote down is that, quote, "I can't believe he has a hit out on me. He wants me gone." Allegedly is what Shara Wright said. And Ms. Robinson said she again tried to discourage her from making those statements, did not believe that it was true, and at some point said that Mr. Billy Turner indicated whether or not Shara Wright thought she was going to be a problem. And Shara Wright responded allegedly, no, she can be offed too. And when she heard that she was pregnant with her first child and she decided that she was leaving, decided not to have any more contact or communications with Shara Wright, did not report it to anybody because she feared for her safety and the safety of her unborn child, and did not report it because she said, especially when she found out that Mr. Lorenzen Wright had been killed, that if this woman just had her husband, ex-husband, the father of many of her children killed, and she's already threatened to have me offed also, what in the world do you think she would do to me? So there's absolutely nothing on the record that would show that Ms. Robinson knowingly, voluntarily, or with any common intent participated with any of these three people in the planning, the execution of any overt steps that would indicate Ms. Robinson is in fact a accomplice to any of the actions that were taken, if any, by Mr. Billy Turner, Shara Wright, and Jimmy Martin. So I would not charge Ms. Claudia Robinson as an accomplice. Her testimony would be considered without any need for anyone to corroborate anything that Ms. Claudia Robinson may have testified to. We'll also charge the jury. Yes, sir. I will give you a chance to respond. Just telling you what I intend to charge, and anything else that you want to object to, you are free to object. We'll charge evidence of other acts, indicating if the witness, they find the witness that's engaged in other acts who have been charged with other crimes. They can consider such prior acts only for the purposes of effect, if any, on the witness's credibility. We'll charge the jury on expert witness. We'll charge the jury on Mr. Turner's election not to testify. We'll also charge the jury on omissions against interest. Any prior statements that may have been attributed to Mr. Turner, either through witnesses or statements that oral statements that he gave to the police, we'll charge the jury on that. We'll also charge the jury on stipulations, charge on jury notes, charge on no outside communications, and a unanimous verdict page. Those are the first 24 pages of the charge. The last 5 or 6 pages relate only to what verdicts the jury can reach and how they go about recording that verdict. And I know you have an objection, Mr. Thomas. You may proceed with any objections or any recommendations that you want the court to consider charging.
I apologize for the interruption.
It's okay.
When you were speaking about Claudia Robinson, when she heard about her being a problem and she could be off, you said that Billy Turner said that when actually it was Jimmy Martin.
If I said that, I misspoke.
Yes,
and I apologize.
Yes,
I apologize if I said that I misspoke. Those words were Ms. Shara Wright's words, allegedly. So if I said Mr. Turner, that was a misspeak on my part, and I do apologize to you, Mr. Perry, and Mr. Turner. It is clearly something that Ms. Shara Wright allegedly said as to why Claudia Robinson decided not to report it to anybody because of her cousin had allegedly just had her husband killed, ex-husband. She had no hesitation that Ms. Wright would have her killed also. So not words that Mr. Turner said, those were words attributed to Shara Wright. If I said anything else differently, charge it to my head, not my heart. It was just misspoke on my part. Any objections to what has been proposed, Mr. Perry, Mr. Thomas, any recommendations? Is anything that you might want included?
No, Your Honor.
I thought about charging alibi, did not charge alibi, because the last witness who testified really did not present. Ms. Bogan did not present an alibi for Ms. Turner. She indicated that she last saw him about 10 o'clock at night. Sheriff Wright's house is 2.12 miles from her house and has no idea where he was before midnight and after midnight, so it's really not an alibi. So I will not charge alibi for those reasons because it's not been properly raised by the proof in the court's opinion. Mr. Hagerman.
The only question I have is on the criminal conspiracy charge.
Yes, sir.
Tennessee pattern jury instructions extend to 2 pages. I wanted to sort of see your charge to make sure we have the entirety of that included. The second page, conspiracy is a continuing course of conduct, which outlines some details of the charge I think are important.
I'm going to go put this on speed blast. So I will try to read it so the court reporter can follow because I'm told that I talk real fast sometimes. Any person who conspires to commit an offense is guilty of a crime. For you to find the defendant guilty of criminal conspiracy, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant entered into an agreement. Basically, what those first 4 things that I will read is exactly what is contained in the preliminary jury instructions that I gave the jury. So those first 4 essential elements are exactly what the jury has already heard. And we'll follow that up with the term intent has been defined in the definition of intentionally in the first-degree murder instructions. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed or the agreement that they be completed is abandoned by the person and by those with whom the person conspired. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. And we'll also define for the jury what the elements of first-degree murder are, which have already been set out and explained in count 1 of the instructions. So that's what the court intends to charge. Is there anything else the state believes should be charged?
Yes, sir.
Okay. Any other objections or recommendations from the state?
Yes, sir.
We'll print this charge and we'll provide it to the lawyers. And once it's been printed, hopefully we'll not have any further objections because I don't want to print 25 more copies. And is jury's lunch here yet, Deputy Phillips? Should be here around 12. We'll print the charges, allow the lawyers to look at it, and jury's lunch will be here at about 12. So as I told the jury, we'll bring it back in the courtroom or send them about 2 hours, and we will start charging this case at 1:30, because it's going to take me a while to copy 20 some odd charges. We'll start charging the case at 1:30, and once the charge is being completed, I will grant deference to at least one juror. It says, Judge Coffey, can we please start on Monday morning? And we'll argue the case at 10 o'clock on Monday morning. Anything else we need to do before we take this recess? We call the court to recess. The court will stand in recess until 1:30 p.m. and we'll start the jury charge at 1:30.
All right.